purpose to harm you.
Threat is a statement of intention to inflict harm. Yeah.
And then we go on to say you don't have to show that the person carried it out or took any steps toward carrying it out or that the person threatened to even receive the threat. In this case, that's true, but the judges did not have to actually see it for it to be a crime. They did see it, but it wasn't required.
In order to drive that point home, could you repeat the state does not need to prove with regard, I think it's only a couple of sentences in your verbal instructions?
Okay, I am going to certainly do it once. If you want me to read that section more than once, then I guess I can do that.
Yes, please.
Okay. They're going to see it 3 times in the instructions when they get the written instructions. If you want me to read that out to them, I'm happy to read that out.
Yes, please.
Okay. Do you have an issue with that, Mr. All right. Very agreeable.
The only other thing is, with regard to the First Amendment language, we'd like the court to add an ignorance of the law is not a defense proviso. Because I take that Ms. Dlefuoco is not just saying I can say what I want, but I thought I could say what I want. I thought law permitted me to do this.
Well, the law is the Constitution. It's written.
Well, I'm not sure she's saying that. I understood her testimony and essentially her opening to be, I did not believe this to be a threat, and therefore I have a right to say these things, because I didn't think they were threats. I think she even said in her opening, if they're threats, they're wrong. Go ahead and convict me. Then I'm wrong. I didn't hear her saying, the First Amendment and my religion protects me. I can make whatever threat I want to make. I don't think she's saying that. If you are, well, I've got to change how we're doing this, but I didn't perceive it that way.
It's a pretty subtle distinction, but I guess we can wait and see if that distinction.
I won't even bring it up. I won't even bring up the constitutional right. I'll leave it alone.
But you can
It's
do
not,
that.
it's
But
not part of my closing argument.
all right, but the issue is it has been a small part of the case. It was, I can't remember if it was mentioned in the opening, but you certainly brought it up in your testimony. So you didn't say First Amendment, I don't think. I think you just said my freedom to speak and my freedom of my religion.
Yeah, to speak about it.
All right, I'll consider whether. I really don't think she's relying on an ignorance of the parameters of the First Amendment. I think she's acknowledged that if it's a threat, then she's wrong. She just didn't perceive it as a threat. Or intended as a threat.
Here's the problem that we have, is I think that generally people think the First Amendment allows them to say whatever they want under any circumstances. And I guess you would say, well, you explained in your instructions that isn't what the First Amendment is.
You have a lot of people fighting in that jury room over that one, because boy, is that a hot topic. You really lay that home today. You might just let me go home afterwards and come when it's done. You know, sorry, let's be real.
Well, we will call you when it's done.
I mean, you know what I'm saying. If you really drive home this whole First Amendment thing with the jury, I think you're just going to have bigger problems than
already I've mentioned true threat twice.
Thank you.
You have any objection to that?
No, that's good.
So I will add that language throughout that instruction.
Can I ask you about the selection of the alternate?
I've always done it completely randomly, unless the parties either have a specific request that a juror be an alternate or they agree that a juror should be an alternate. Is there any situation like that?
Well, so 2 points. One is that we had the issue with the bourgeois siblings, and while the court found that there was not cause to strike one or the other, it still seems like an unusual circumstance, and that deliberations would be better served not to have them both in the deliberation room, and so we'd ask that one of them be made an alternate.
Do you have a position on it?
Well, I think if they're already going at this position, we already said it was okay, and they both said that it wouldn't affect them in any way, leave them be. And obviously, they're doing the jury thing over here, looking at them, and they're a little bit more nervous, and I don't know, that whole boy, man, was supposed to read the jury. I mean, let's face it, there's 2 of you here, both of you are sitting here taking notes, there's only one of me here. So obviously, they know something about these 2 that I missed, so I'd like to leave it the way it is. They both said that wouldn't affect their Christmas and Thanksgiving, that's all I cared about.
Well, as it stands, the record that was made at the beginning of the trial, that their relationship with each other would have no effect on their ability to deliberate the case. I'm inclined to leave it as it is. If something occurs between now and the selection of alternates, I may change my mind. But otherwise, if they're randomly, if one or both of them is randomly selected, then problem solved. But if not, I don't really think there is an issue.
I really have a question on the second point, and that is the court rule on jury selection talks about peremptory challenges with regard to the alternates. We don't have experience with that, and I wonder.
Well, if I'm thinking of the same thing you're looking at, that's when, at the beginning of the selection, you're given an additional peremptory for, I think it's either every 1 or every 2 alternates that are going to be selected.
Oh, I see.
Right. My understanding is the rule isn't designed to give you the right to strike an alternate after they've been impaneled. Whether an alternate is chosen is usually up to the discretion of the court how they prefer to do it.
That makes sense.
And I think at the beginning you both were given 4. By statute, I think it's 3, and then by rule, or no, even by statute, you get additional based on how many alternates we have. That's why I gave you each 4.
That makes sense.
Okay.
Thank you, Judge.
All right, so I'm actually going to make these changes while we have a few minutes here, and then when I come back in, we'll bring the jury in and start the close.
So you got 2 minutes just.
Oh yeah, you'll have 10 minutes for sure. Ms.
Thank you.
Dlefuoco, if you didn't already know this, you go first at this point. State has the burden, so they get to argue last.
Oh, Your Honor, we did have one other.
There's always one more.
I'm sorry.
I should learn to just run when I say I'm going to run.
I'm concerned that Ms. Dlefuoco, not having done this before, might, in her closing, argue back that arming evidence and argue things like the court's opinion yesterday that the case was a close call.
No,
Yeah,
that's
you
not
know
what I
it.
asked you.
Right, you know
Can I
it.
explain?
Oh, no, this is a different
me back into the courtroom. The main element that I divorced, the main element that I was trying to get away from, kept filing the ex parte orders, kept bringing me back into court, kept doing things, you know, it's like they said, they kept, over 30 times at some point, it was like once a week. It's because he couldn't stop bringing his presence into my world when I was trying to run away. So every time his presence was there, they were seeing the anger, and I was angry at him. I was angry at him. I was aggravated, and I was hurt that they weren't protecting me, and that's what I said
That,
on
I
the
think,
stand.
that part, I think, came out yesterday.
It did. I was
So
angry
the
and no.
only thing you've said so far that gives me a little bit of concern is labeling Mr. Go an abuser.
All right, I don't have to.
Just because I'm not sure there's been, anybody's made reference to
right.
that. There's certainly been reference to numerous pleadings filed by him and by you, and I think you can say he kept dragging me back into
Can I
court.
just say,
I kept
this
fighting
person
him.
was in the room that I was angry at, and I was,
I
I don't know how to even
I
word
don't
that.
think that's an unfair argument. I think that's, you're not offering the evidence. I think you're.
I'm trying to explain why
It's an
everybody's
inference
perceiving
from what the circumstances
you know, everyone thinks I was so angry that I wasn't angry, I was hurt. I was angry at him, and it was just being heightened, that it was just such a mess.
Right. I don't find that particularly unfair. Are you concerned about that?
I don't think there was evidence that Mr. Goode was in the courtroom, I mean, every time.
Yes, he was, that's why I was there.
Well, every time, I'm not sure about that. Every instance that was spoken about at hearings, there was testimony that he was there. That's, in fact, it was usually because he brought the motion, and then the judge would say there was an ex parte situation. Then we had a hearing for both of them to be there, and I made my decision. I think you asked these questions.
Yes.
Based on the testimony of both parties.
Of Judge Weaver, though, Your Honor, and one of the cases in the Rockland County Superior Court was Ms. Dlefuoco's case against Mr. Goode, but two were not.
Right, the
they
one
both
against the
only-
bank was
That was
usually
yeah,
there.
that was usually, but it was
So that argument
with
wouldn't
him,
have-
it was more toward when he was in the room.
I think you have to draw the distinction that argument about him being in the room doesn't apply to the bank case, right?
Right.
I don't know if he was there. I don't think there's evidence of that.
He was, but we don't have that.
I just don't think there was
It's not
evidence.
even gonna be part of
I
like,
remember when-
it's gonna be like the first like 2 minutes to just clear it up of them thinking, well, she's up here telling us she was never angry, that she was hurt. I was angry, but they were all saying she was angry. Well, I was angry at him for everything I was still going through. I wasn't even angry at myself for even putting myself into this predicament. And I wanted to say that too. But when it came to them and these posts, I was hurt. And that's what I was going to say. And then I was going to like really put to the real
I
argument.
think most of that is fair, and so if I think that you're getting a little
I'll
too,
stick with just that. I won't
I think
go
if
much
you're getting
back.
too far afield, you're probably going to object, and then I'll take it up at that point, but try to keep it contained essentially to what you just told
I'll
me.
just leave it just as that.
All right. Okay. Give me a few minutes to fix this, and then we'll get started.
Please rise. May be seated.
You came out with that, I think, a half an hour after we left. That was fast, your article. By 4:30 you had it out, didn't you? Yeah.
Oh, she has an article about it?
Yeah, the union leader.
I'll have to check it out.
Foster's also
Yep.
had something.
People are sharing your article about 100 times more than Foster's, fortunately or unfortunately. I don't know.
Well, I mean, I think that it's an interesting case, and people can certainly relate to it.
Yeah, yeah.
So your live stream, I was listening to some on the way in, you can barely hear it, so I don't
That's
know
your
if there's any
phone.
way.
Just crank your phone up.
Yeah, it was all the way up, so I don't know.
It's maxed on my end. It's the distance, it's the echo.
I tried to put it on Bluetooth and turn it up. I couldn't.
Nothing I can do about that.
I know, I was trying to hear some of it on the way in, but
I can't believe
I'd ask you some questions on camera, but technically not allowed to do any interviews in the court.
Oh, yeah, you'd have to go outside. That's what we typically do. Yeah, I like courthouses a little bit different. This courthouse is pretty lenient with allowing us to interview right outside the courtroom, which is great. At some courthouses, like Rockingham County Superior Court, you have to go to like a specific area, and sometimes that involves getting somebody to come like upstairs or downstairs. So.
Do you want to, this is wireless, I can unplug that if you want to interview her. I can film it and give you the footage if you want.
Sure. After closing.
Yeah. That would be awesome.
Because I wasn't able to make it yesterday, so I'm behind on.
There's a lot of people here yesterday.
I was in contact with one woman who was planning to come today. She wasn't feeling well this morning.
I think she called me. I don't know how she got my number.
Elizabeth?
She didn't.
Yeah, she said she talked to you, so that would have been the same person.
What was her name? Elizabeth?
Ramsey, I think. Wansley, Rawnsleigh.
I was going to look her up. If she's on Facebook, you'll find her.
Probably. A lot of people are nowadays. It's amazing. I never ever was interested in Facebook, but I use it for work, and it's a really effective way of reaching people.
It is their ability to advertise in a local area is unlike anything else.
Well, just as far as like direct messaging people, like years ago in our newsroom we had like stacks of telephone books. Like, and if you needed to contact someone, you went over to the telephone book in that local area, you know what I mean, and find their number and they pick up. And now a lot of times, even if they have a landline, they don't necessarily pick up. So unless you have a cell phone, it's very difficult to reach them. So I use Facebook all the time because people are like at lunchtime they're scrolling, you know what I mean, and so they'll see the message. So it's been really great, actually.
Yeah, I bet. It's too great sometimes. I turned off notifications. I used to get
No,
ding,
I
ding,
don't.
ding, 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 ding.
I don't do any notifications for anything. I refuse to. I would be pinging all day.
Yeah.
And I know journalists that are like that, and we'll go out to dinner, and I'm like, put your phone away. I yell at them.
You don't turn it off.
Turn it off. I want that. Like, you're stressing me out with all your notifications.
It's really unbelievable. I did a show for a while, and I produce other people's shows. And when I was doing that show, the notifications were insanity. It was constant. And it was to the point where you don't want to even look at it. It's still pinging.
Yeah. At the end of the day, I try to put my phone like out of reach. You know what I mean? Like in my bedroom or someplace where I'm not. You couldn't look at it or see it. It just gets to be too much.
Yeah, it'll keep you up forever.
Yeah, and it's like stuff that I can't do anything about right then anyway.
Exactly.
You know what I mean? Like the paper's already printing on the on the presses. I can't add anything. I can't change anything. Like that's that.
So that article, it was online instantly, but it was a paper the next day. Is that how it works?
Yeah. Typically now that's what we're tending to do a little bit more. For a long time, we always waited for things to go to print before we posted it online. But our readers just have changed so much over the course of years that we can't do that anymore.
Do you offer more services in exchange for some kind of a subscription, online subscription?
Yeah, we have online subscriptions and stuff like that, so people do subscribe. And, you know, not everybody who's interacting with us gets a subscription. Like last year, I think I looked at the total numbers, I just saw there were over 40 million interactions over the course of 2018, but not every single one of those people is paying for a subscription. You know, they might just be interested in one article because it pertains to them or their business, and they'll view it for free and share it. And hopefully other people will view and share it as well.
That hopefully
And
subscriptions.
that hopefully will boil down to that, but it's very different than back in the days where like you either had to subscribe to the paper to get the information or buy a paper off the shelf or go to a local library, you know what I mean? Like people can get everything again right on their phones.
Yeah, when I grew up in Hanover, I never heard of the Union Leader. We have our own paper called the Valley News.
Yeah, the Valley News is very prevalent there. Just like here, Foster's Daily Democrat is very prevalent, or in Portsmouth, the Herald is very prevalent.
But now it's run by a company of Concord now prints it.
The Concord Monitor is printing our paper as well. They just, there's a big
Did they
court.
shrink your paper too?
There's a big court case going on right now because they had outsourced printing from the Union Leader. My husband is in charge of for production, so we met each other at the Union Leader years ago. And so we moved out here because they outsourced for production and stopped printing in Manchester, and they've been printing across the street at Foster's Daily Democrat. But they stopped doing that a couple weeks ago, and now they're printing at the Concord Monitor. The Concord Monitor has built a new facility just outside of Concord, and so Valley News is one of the ones that jumped to that. Union Leader jumped to that. So,
But literally, it's been 3 weeks. The regular size paper, you know, it took a quarter of it.
well, also too, they're only doing one edition, so it's really hard for us. Like I have a story that we put online last Wednesday that won't go into print till tomorrow.
Wow.
Because we just don't have space anymore.
Yeah, that
Like
quarter.
when they change when they change printers, the contracts change, and so I think Concord Monitor doesn't have to do all of our sewn editions anymore. We used to have like a Derry Londonderry edition, like the state edition was always bigger than the city edition as far as like depth, you know, and reach of stories.
Does that do anything to your bottom line or your
To me,
work?
yeah. Because like if they stop taking as many articles,
That's less.
you know, I'm a freelancer, so that's less revenue for me. So I have to think of other ways to make that up, and maybe that's sending in more photos, and hopefully they use them online at least. And, you know, maybe thinking about doing some other freelance work. I haven't picked up any other freelance gigs in a while. After NH1 went off the air, I still freelance with them until they decided they weren't doing like any news anymore. So that was pretty good. I could do my work for the Union Leader and then like write scripts for the radio or TV and send video and stuff like that. So that kind of worked well together. But now I'm thinking about different things that I could pick up and exploring different options, because another challenge, like part of the reason you saw the article so early is because they want all of our articles in by 4 o'clock.
Oh, really?
Yeah, to be able to organize and get everything shipped off to Concord, because now they're in line, they're in queue with all these other papers. So the last like couple weeks, honestly, Ted, at night I've been bored. I'm like, you know, because I'm used to working at 8 o'clock at night. Like that's just your lifestyle. If you have a deadline that's 8 o'clock, you end up working till 8 o'clock, and now my deadline's 4 o'clock. So it's been great. I've been bringing my dog for lots of walks and stuff like that. But I'm like, this is going to catch up to me bad, you know?
Quality of life goes up, but revenue goes down.
Yeah, like one way or the other. Like, so.
Well, if you need somebody to broadcast or film, you know, I'm 2 hours away.
Yeah. So what kind of shows do you do? Where if you air them, is it all digital?
Yeah, most of the shows I produce are usually law related, you know, or law reform related. People I know through the family law community usually. There's one called The Healing Tree that just started with a guy out of Colorado. He had his kids taken, 5 kids taken from CPS. He has them back now. He was in the news quite a bit because he did a 3-month-long hunger strike on the White House, or on the White House
Oh,
step.
wow, yeah.
But part of the reason they took them was because of his use of marijuana, PTSD from the military. He didn't want to take prescription meds, so he used marijuana. They took his kids for that. Yeah, not Colorado. The next.
Please rise and go to closed session.
Because the laws are,
Yeah.
yeah, we have that challenge here.
May be seated. All rise, jury entering. Please be seated.
Good morning, ladies and gentlemen. And at this time, we're going to be having the parties' closing arguments, which will be followed by my final instructions. Ms. Dlefuoco, you go first, so your closing argument.
Everything changed a little bit since you first heard the charges, huh? It wasn't what expected. So I'm gonna just start off like the first 5 minutes. I'm not gonna act like you see, you know, I'm gonna bash you that you're not guilty. I'm not taking that approach. I haven't taken the approach yet through this whole trial, and I don't intend on taking any kind of approach like that. The judge has let me say something, and I'm gonna kind of quote it as perception. It's about perception. And the perception part about this is, you know, I've talked over and over again how I had all these interviews from the AG's office, what people were saying right after. I kept quoting people on it. And the last few days I've been my own worst enemy. I've been going home. I've been going over all of this. I've been re-listening to it, and I've been listening to these judges. We're not in the same courtrooms anymore. We're out of the situation. And I kept thinking, why is everybody thinking that I was so angry at them? And yet I got up on the stand and I said, I was never angry, I was hurt. But yet they saw it as angry. So I had to really play with that in my head and say, why did they keep seeing that? And I had to do the worst thing imaginable. I had to go back to that time. The reason why I proposed, too, that time, that whole entire 5 years, I had to go back there. It's an area I've tried to forget. I had to go back there. And I had to put myself back in that courtroom in Rockingham County, all of them, and say, why was their perception of me and everybody thinking I was always so angry, but yet I had the nerve to get up on that stand and say, I was never angry, I was hurt, I was in pain, I wanted someone to help me. No one would help me. And then it came to me. They were seeing me trying to take in all of the energy from being in court, dealing with what I was dealing with, and the worst energy that was most of the time, 99% of the time, standing right next to me. The one thing I was trying to run away from the most. There's a reason I got divorced. There's a reason I got rid of them. But I made the biggest mistake by giving them an equity loan off of my house to keep them close to my kids. So when I first got rid of them, kind of brought them back a little bit, and then I was really trying to get rid of them, and I was dealing with all these emotions of a divorce, child custody. I mean, I had the kids. They told you I had the kid. There was no issues. But all of a sudden, you know, things were being said, things were being done, things that people go through a divorce. I was dealing with all of this at once. So their perception of me was, well, she was angry all the time. I was angry at myself. I was angry at him. I was angry at the situation. I was never angry at them. I was hurt. that they would never take their authority figure and step up to the plate, in my eyes, and stop what was going on. No one stopped it. Everyone ignored it, and I cried, and I yelled, and I screamed over and over again, and I was bad. I was bad in those courtrooms because I had no way out. And I kept saying, why aren't you helping me? And yeah, I got up and I stormed out of that courtroom because I was being tired of him. And it was said to me, what is he said it? He said that both of us were being bad parents. And I couldn't comprehend it in my head. How the hell can a mother who takes a homeless ex off the street give him an equity loan and I'm a bad parent? How is that happening to me? How does it happen? Would any of you do that for an ex? If you would, don't. If you're going to come into that situation, don't. If you're going to learn anything from this today, even if I'm found guilty, at least take away what I went through. Remember, people are constantly watching you on Facebook, whether you know it or not. We all learned that lesson. I learned it. I leave my Facebook page open because I only have 152 friends on there. I keep it closed to certain things, like when I go away or just private things. I belong to motocross organizations, so I keep it, you know, just friends with motocross and stuff because I need to see the schedules. I need to see who's going where. You know, it's a big family, motocross. We all travel up and down the East Coast. Both my boys have done it since they were 5 and 7. But I keep the rest of it public because I have a lot of other friends that I don't want on my page. And I leave it there. So sometimes my settings are private, sometimes my settings are public. Sometimes I don't even pay attention to my settings. You saw yesterday that they were bringing up, you know, posts, and I was like, whoa, wait a minute, some of these were private, you know? Yes, the main post that I'm in big trouble for was public, but a lot of the other ones were supposed to be private, and I'm like, woohoo, what happened to you? You know, search warrant. And then it comes back down to, again, the AG's office called me right after the post. What is this, Janet? We know you, we know you, we know you're going through a hard time. We know, you've been here. Dick Tracy said, we go back. I've complained about the bank, I complained about the equity loan, I complained about the way I was being treated by everybody. Why wasn't anyone helping me? I went to every agency and said, why aren't you helping me? Why am I losing my house? Why am I losing my kids? What did I do? I thought it was cleared up. I thought it was over. His last words were to me, I'm going to call the bank. I listened to the tape again last night. It's hearsay, but those were the last words. I ended it. I thought it was over. I kept going back and forth to court, kept fighting, kept arguing. Finally, I just got up, like Judge Weaver said, and I walked out. And I never went back again. I was like, I'm done. I can't do this anymore. I'm at my breaking point. That was months after I'd written the post, I think. No, strike that. I'm not really quite sure. Anyways, I went back again after I'd written the post, and I was still dealing with him and the other court, him and the bank. I was dealing with them in Rockingham, of course, but now on a different floor. It was, you know, the whole bank thing and, you know, him not paying me and losing the house and just all the other drama. And I was still going through it, and I was still getting angry. And I didn't think anything of it. They'd already called me about it. It was done. It was over. So why was there a whole year investigation? Why was I arrested instantly? Why didn't anyone come forward and say to me, we all know you. We've been dealing, I'm not a stranger where, you know, they had to send the SWAT team. They got a 911 call and they had to send the SWAT team and say, oh my God, go surround the house. They knew me. They saw me all the time. They were calling me. Why didn't they just say, we saw the post. What did you mean? What did it do? Why don't do it again? Instead, they take out search warrants and they follow me for a year. Why? What's the purpose? And that's the answer I never got today. I never got it. Why were they watching my Facebook page, even on Sundays? She should have just Facebook friended me. I didn't know who she was. I probably just would have accepted it. She wasn't a close friend. She could have lied. She could have said she was somebody else. I don't do, you know, FBI on my Facebook. I always thought Facebook was just a thing. 52 years old. I think it's stressed that day. There's no excuse for that. I wanted it to be calmer. I wanted the energy to stop. I wanted the negativity to stop. I said that yesterday on the stand. I didn't want to go out and quote-unquote kill anybody. I wasn't going to go murder anybody. I didn't want to hurt anybody. I wanted the energy to stop. The AG knew that. So I still need answers. I still need to know why, if they thought it was okay for me to keep going, why am I here today? And those are the answers I don't have. Those are the answers I'm going to need at some point. Someone needs to answer to me about this. Why are we all here? I admitted to doing it. I could have lied. I could have said, I didn't write that. Someone hacked into my page. I'll bet you that was my ex. He probably did it. He wrote it. I'm getting it. Yeah, I did it. I'm wicked sorry. Let's go through the whole post, word for word. Were you threatening to harm? Were you threatening to kill him? Did you want it? No, I just wanted calm. I just wanted it all to go away. That's what I said. Just wanted it to go away. I wanted them to go away. The first post clearly says how those people got sick. Those people are my family. It's my uncle, it's my sister, it's my mother. Were they part of this divorce? Yeah, these are people I never even saw. And they had their role in this that hurt me so badly that I couldn't even believe that they did what they did, considering they didn't even know my kids and they hadn't even seen me in years, but yet they were brought back in. I was very distraught about that. I felt very stabbed in the back. And at this point, I was beyond my heart being just stabbed. It was gone. It was just totally removed. But I still keep coming back to, they knew it. They knew I did it. I already explained it to them. I didn't go kill anybody. I didn't harm anybody. I didn't threaten anybody. I said, Karma did this to you. And then I said, next, next, next. Karma, next, next, next. You just freaking wait. Yeah, I said freaking. I didn't say my favorite word. Because we all found out what my favorite word is, right? We all found out. I won't say. But, you know, I'm not going to sit here and say that, you know, I have the personality of a lady. I'm a motocross mother. I couldn't wear high heels and a dress today. I lasted 2 days. Last night I was packed in ice, back down. My legs were spasm. Forget about the shoes. That was a show for respect. Today, I'm comfortable. This is me. This isn't even me. Usually it's jeans and a sweatshirt. I have a mouth. I'm from Boston. I'm Italian. You may or not think that's a good reason to, you know, have the mouth of a sailor, but I grew up in the 70s and 80s where nobody cared what you said. It was just there. I can't change with these times. I'm too old. And I'm going to swear. I'm going to say how I feel. I'm going to think that I grew up in a day and age where it's okay to express your opinion and not realize this. But this is this. And here we are, two years later. Here we are, 2 years. Not 4 or 5 months, not 6 months, not even a year. 2 years later, here we are. So every little Band-Aid I had healed over is now ripped off again. Except this time, I didn't put a Band-Aid on with the scab. This time the Band-Aid's off and I understand what I did and it was wrong. But a true threat? No. No. From the bottom of my heart, I swear to God, it was never a true threat to harm somebody. And if I thought it was and I was going to try to get out of it, I would have tried to get out of that Facebook post a long time ago. So I'm going to say to you, I'm not going to sit here and say to you, you got to give me killed. You decide. Whatever you decide, you decide. You got to live with it. Thanks. Thank you.
You might feel sorry for the defendant observing her behavior in this courtroom over the course of the last 2 days and today. During her closing argument, she's been tearful, sometimes seemingly remorseful. But as the defendant seemed to just acknowledge and the evidence showed you, that is not how she acted in Judge Weaver's courtroom. That is not how she acted in Judge Anderson's courtroom. And that is not how she acted towards Clifford Gallant. What the evidence shows is that Janet Dlefuoco had waged a war against those judges and Granite State Credit Union for more than 2 years. She repeatedly attacked them on social media, calling the judges and Cliff Gallant corrupt. She used foul, ugly language. She illustrated a Facebook post about Judge Weaver with a pornographic photo. Remember this? My ex-husband, Jim Goad, with the New York court system, at least I have balls and don't need to suck balls. Fuck you and your RSA 461 A11. You should be sorry I was treating you like a man and not a pussy. Don't worry, Jim shaves it all. Arms, legs, all of it, so suck it. A clear reference to Judge Weaver, who told you it was his responsibility as a family court judge to apply the law to use that statute, RSA 461 A11. The defendant yelled at Judges Anderson and Weaver. She yelled at them in their courtrooms. She threatened Cliff Gallant by telling him at that hearing, after the hearing in January 2016, this is just the beginning. She had a temper tantrum in Judge Weaver's courtroom. She just told you that she did. And as he testified, she yelled, she screamed, she cried, and she walked out. She screamed at Sandra Pease, the court clerk, in April 2016. Sandra Pease, who told you that the defendant was loud, angry, used profanity, yelled at her for about 5 minutes straight. Sandra Pease, who told you on that phone call that the defendant's anger was directed not at her husband, but at Judges Weaver and Anderson, who the defendant accused of being in cahoots against her. Sandra, who told you that in 28 years of being a court clerk, the defendant's anger was a 20 on a scale of 1 to 10. Now, some people in the back of this courtroom laughed when Sandra Pease said the defendant used the word fuck on the phone call. Maybe they think it's funny that people treat each other that way. It isn't. But either way, it's true, it wasn't a crime. It wasn't a crime to be rude and demeaning and vulgar to Sandra Pease, a career clerk who had no dog in the defendant's fight. The defendant is entitled to choose vulgar words she uses. She can tell Judge Weaver to suck her ex-husband's balls. The defendant is entitled to use words that criticize. She can call the judges and Cliff Gallant corrupt. That, ladies and gentlemen, is a crime. And that is why we're all here today. You heard that the defendant was you heard testimony that the credit union home equity loan that you heard testimony about that loan and that it used the defendant's home as collateral. And guess what? The defendant wanted that loan discharged, and Judge Anderson determined that the law did not afford her that relief. As in, it would not have been lawful for him to do what the defendant wanted and discharge the Granite State Credit Union loan. Judge Anderson granted the defendant what the law permitted him to grant her. He ordered her ex-husband to pay her $500 a month for a total of about $13,000, but he could not, by law, remove the home equity loan as the defendant repeatedly asked him to do. And what facts did Judge Anderson find particularly important in his decision to deny the defendant the relief that she requested? He told you, she admitted that she agreed to the home equity loan. Ms. Dlefuoco told you that in her closing argument. The defendant admitted that she agreed to the loan and admitted, this is Judge Anderson's testimony, that she signed the home equity loan document. But the evidence shows that the defendant refused to accept
that agreeing to that home equity loan was her mistake. It was her fault. And nonetheless, she wanted somebody else to pay. And when she didn't get her way, on Sunday, February 5th, 2 days after she learned of Judge Anderson's decision, giving her the time to think about that decision, to think about how she wanted to react, to think about what her options were, she sat down and typed out those 3 Facebook posts. What were the defendants' February 5th posts? They were retaliation for actions the judges and Clifford Gallant took in the course of their work. There were threats to do bodily harm, to commit a crime against the 3 individuals she believed in the course of that litigation over the span of 2 or more years. She believed that they had wronged her. When the defendant sat down to type those posts, she wanted to get even. An eye for an eye, remember? I asked her about that. And no, an eye for an eye. It's not just language the defendant used to explain to a man who might not understand what karma is. She didn't use the language an eye for an eye in her opening statement to you when she talked about karma, and half of you here are men. No, an eye for an eye is the defendant revealing her true colors: angry, spiteful, and vengeful. You better believe that when the defendant learned of Judge Anderson's Friday, February 3rd order, when she learned that Judge Anderson had dismissed her complaint, her call for the credit union, for the home equity loan to be removed from the home, you better believe she was furious. But remember, furious at that point wasn't a new state of mind for the defendant. She had been furious at Anderson, Weaver, and Gallant for a good long time. She didn't get what she wanted. She was going to get even. She lost that litigation. She didn't get her way. And she posted those posts. You've heard them time and time again. And she used those words. Let them all die and suffer. That judge, those judges, and that fucking attorney are so next. Next is Weaver, Anderson, and Gallant. I will give you the shirt off my back, but I'm also just as capable of killing you off. Don't ever cross me with corruption and greed. Her words, the words that she thought about, the words that she typed letter by letter, the words that she chose. So let's talk for a minute about what the state has to prove to you. There are 5 charges. 4 of them concern the judges. And with regard to those 4 charges, Judge Howard will tell you that we have to prove these elements. That the defendant purposely threatened bodily injury or threatened to commit a crime against a member of the judiciary in retaliation for action taken as a part of the government official's duties. There's really only 1 charge for each judge, but it's charged in the alternative. That is 2 different ways. So you can find that the defendant's words in her posts were threats either of bodily injury or threats to commit a crime, or both. There's 1 charge concerning attorney Clifford Gallant, and Judge Howard will tell you that in order for the state to prove to you that the defendant committed the crime of criminal threatening, we have to prove beyond reasonable doubt these elements: that the defendant threatened to commit any crime against the person of another with the purpose to terrorize. And terrorize in the criminal threatening statute has a specific definition. So what Judge Howard will tell you is that it means to cause alarm, fright, or dread, the state of mind induced by the apprehension occurred from some hostile or threatening event or manifestation. I want to talk briefly about 3 of the elements of the crimes involving the judges. We have to prove that the defendant's threatening statements on Facebook were threats of bodily injury or that they were threats of a crime. The language of the defendant's threats itself, that language, establishes that proof. In her post, she threatened to kill off Weaver, Anderson, and Gallant. Killing another person causes them bodily injury. Killing another person is a crime. It's really that simple. And that's how the defendant's victims victim was concerned for his own safety or the safety of someone he worked with. And each victim believed that as a result of the defendant's threats, that it was possible that the defendant might actually cause them harm. We also have to prove to you that Judge Anderson and Judge Weaver were members of the judiciary, and there's no question about that. Both judges told you that they are judges. They told you how they became judges. They told you that they were employed by the judicial branch of government, and the defendant doesn't dispute that element of the crime. We have to prove to you also that the defendant retaliated against the judges for action taken as a part of their official government duties. So did the judges take certain actions that were part of their duties? Of course they did. Both judges testified that the orders that they issued in the defendant's cases were actions that they took as a part of their responsibilities of being a judge. Judge Anderson testified about the orders he issued in the defendant's litigation with her ex-husband, James Goad, and Granite State Credit Union, and Judge Weaver testified about the orders that he issued with regard to the defendant's parenting issues and the home equity loan. Both judges told you that they came to the decisions in their orders by assessing the law and assessing the facts in the defendant's cases. So let's talk about retaliation. There is no question that the defendant posted those threats to retaliate against Judges Weaver and Anderson for decisions they made in her cases. And how do you know that? Well, first, the timing of the defendant's Facebook posts on February 5th and Judge Anderson's order on February 2nd made clear that she was retaliating. Judge Anderson's order was signed and finalized on the 2nd of February. The defendant learned about this order on the 3rd of February. And we know that because she used Facebook to talk about it that Friday, February 3rd. I'll read this one to you because it's not legible, but on February 3rd, 2017, the defendant posted, "My case was thrown out." You know also that on February 5th, she used Facebook to talk about Judge Anderson's order, and that post says, "So after reading my decision, I can safely say that the judge is fucked." That last line alone with him saying the credit union can't be held responsible. And that post was posted before the threats at issue here on February 5th. And you also know that the defendant retaliated for actions that the judges took because of her repeated demands to have the home equity loan removed from her home. Those repeated demands made it clear that her February 5th posts were threats to retaliate against the judges for denying the relief that she requested. In the course of each of her 3 cases in the Rockingham County Superior Court, the defendant repeatedly asked the judges to remove that home equity loan. Judge Weaver said that before his October 2014 order, she asked to remove the second mortgage. She did it again in a motion in October 2014 in the Rockingham County Superior Court. She did it again in October 2015 in Rockingham Superior Court, again in November 2015, again in February 2016, another motion in February 2016, filed in one of her other cases in the Superior Court, again in March 2016, May 2016, and September 2016, repeatedly over and over and over and over again, asking that the judge remove the home equity loan from her home. I know that it was tedious for you to have to sit through the judges testifying about each of those motions and some of their orders, and I'm sorry for that. But those motions of the defendants over the course of 2 years, they show you that on February 2nd, 2017, when Judge Anderson denied the relief that the defendant wanted, she had an obvious motive to retaliate. So what else proves that the defendant retaliated? Her history of ongoing sustained anger at the judges and Attorney Gallant. And maybe that anger comes from a place of hurt, as the defendant just suggested to you it did, but that hurt made her mad. And you know that because of the angry language that she used. The ugly language that she used in the course of her litigation in the Rockingham County Superior Court and in the family court in Brentwood. You know that because of the defendant's behavior in those courts. You know it because she yelled at Sandra Pease and used profanity. And you know it from the defendant's own testimony yesterday. She told you that one of the persons that she was most angry at was Attorney Gallant, and she told you that things got heated. All this evidence makes clear that the defendant had a motive. Her intent was to retaliate against the judges. You know also that the defendant had another motive to retaliate against Judge Weaver, so it wasn't just that he denied her non-parenting issue request to remove the home equity loan from her home, but also because Judge Weaver made certain orders that prohibited the defendant from initiating contact with her older son. Judge Weaver assessed the facts and applied the law in the defendant's family court case, and he came to the decision that the defendant should not initiate contact with her older teenage son. But the defendant did not believe that the law applies to her, and so Judge Weaver's orders concerning her son made her angry. So the evidence makes it clear that the defendant posted those threats on February 5th to retaliate against the judges and Clifford Gallant. But what else does the fact that the defendant retaliated tell you? It tells you that her actions were intentional. It tells you that she acted with deliberation. It tells you that her actions were purposeful, that she had a purpose when she typed out those words on February 5th. It was the defendant's conscious object to get back at the judges and Clifford Gallant. How? By threatening them. Her purpose was to threaten. Remember the language of the criminal threatening statute. She wanted to cause her victims alarm or fright or dread, the state of mind induced by the apprehension of hurt. She wanted to make them worry about being harmed. Those posts on February 5th were not some momentary outburst. No, the defendant wasn't just venting. She wasn't just ranting. And you know that because she had waged a campaign to discharge that home equity loan for more than 2 years. She was angry at the court system, she was angry at the credit union, and she was angry at Clifford Gallant for that entire time. You know that the defendant's threats weren't a momentary outburst of anger. They weren't just venting and ranting because she had 2 days to think about what she was going to do after she received notice of Judge Anderson's order. She didn't write the threatening post for another 2 days after she learned of the order. She had time to consider her options. She had time to make a decision. She had time to calm down, and her decision was to threaten. She typed each of the words in that first post, and she hit post and uploaded them onto Facebook. And after she did that, she had time to think about what she was going to do next. She had time to think that maybe she wouldn't do anything. She had time to think maybe she'd type something else. She had time to think, I should take that post down. But no, her decision was to type the words that constituted that second post. And after that second post, she had time to go through that same mental exercise of what am I going to do next, if anything. And she chose, letter for letter, word for word, to type that third post. So no, those February 5th posts weren't just venting. This isn't someone reacting in a split second and blurting out some hateful thing. It's not someone having a heated argument over the phone and blurting out, I'm so mad I could kill you. No, the defendant had time to think about Judge Anderson's order, time to process, time to decide what to do, and her decision was to threaten. This also proves that the defendant acted purposefully. And this idea that somehow the defendant's threats aren't really threats because there's some kind of karmic Wiccan spell, that's not a defense. How convenient to blame violent, threatening words on religion. But that Wicca defense, that scam, it doesn't work. Because even if you believe that the defendant is a practicing witch who can kill people with curses, or believe that that's what she believes, you still have to include that her intent was to threaten bodily harm. Why? Because the defendant chose violent words to convey her violent intentions in those posts. Die and suffer. You're next. I can kill you off. You think the judges and Attorney Gallant read those words and thought, oh, that's just karma? Of course not. They understood that violent, threatening language to be exactly that. And mind you, the defendant has chosen violent, threatening language at other times. You saw a post in which she said, when I say something, I'll act on it. And you heard the language about an eye for an eye. She didn't turn the other cheek. She did the opposite. An eye for an eye. That's what those posts were. The language she used in those February 5th posts, whether Wiccan, Christian, Muslim, agnostic, whatever, the language is threatening, period. The defendant intended to use words that threatened bodily harm. So what were the reactions of the targets of the defendant's threats? Clifford Gallant told you that he was concerned when he read those posts. He said that in 30 years of practice as a lawyer, he had never had such statements made against him. The posts, he said, were off the charts. He viewed those posts as threatening. No question in his mind that they were threatening, and he took those posts seriously. He told you what language he took seriously. The judges and that attorney are so next. And remember what Attorney Gallant said when the defendant cross-examined him on Monday? I didn't know what you would do. Attorney Gallant made sure that the Manchester Police Department was aware of the defendant's threats, that the Office of the Administrative Courts was aware, and that the Attorney General's office was aware. And once that happened, he felt that he had done what he could. And what about Judge Anderson? He was surprised, he said, because the defendant's February 5th posts had not previously taken the tone that these posts did. These posts were different. Judge Anderson told you that he found the language of the defendant's post a little disturbing, especially where she said that she was just as capable of killing you all. So despite the fact that Judge Anderson didn't consider the defendant to be a dangerous person, he told you he was concerned for his safety. He was concerned for Judge Weaver's safety, and he was concerned for Clifford Gallant's safety. He alerted court security. He told you that court staff was there to be on the lookout. No, the courts didn't hire extra security, but they had additional security available, additional bailiffs available in case they needed it when the defendant came to court. And what about Judge Weaver? Judge Weaver told you that he considered the defendant's posts to be a threat. He made sure that his clerk knew about them. He made sure court security knew about them. He was concerned about the language in the defendant's post where she said that judge and the fucking attorney are so next. He was also concerned about the language where she said, next is Weaver, Anderson, and Gallant. I am just as capable of killing you all. Each of the victims was alarmed. Sure, none was convinced that the defendant would act on her threat, but the defendant knew where Cliff Gallant worked, and of course she knew where the judges worked. So what if the defendant made good on her threats? What if the defendant showed up in court with a weapon? What if the defendant showed up at Cliff Gallant's office with a weapon? The office that she had the address to, because he put it on every pleading that he filed in her cases. What if the defendant hurt someone? As the language she used in those posts said that she wanted to do. That, ladies and gentlemen, is the hallmark of threatening words. Threatening words cause their victims to worry, what if she hurts me or somebody else? Threatening words cause alarm. That is what happened here. That is what the defendant did to her victims. She knows what she did. She told you yesterday, and again today, that what she said in those posts was wrong, and that's why she took them down. Now bear in mind, there are several things that the state does not have to prove to you in this case, and Judge Howard will instruct you about those things. Judge Howard will tell you that we do not need to prove that the victims, Judge Anderson, Judge Weaver, and Attorney Gallant, were actually placed in fear. We told you at the outset of this case that you were not going to hear that the defendant's victims say that they were actually terrified when they read those threats. We were upfront about that. And that's because we don't have to prove that they were actually placed in fear. Judge Howard will tell you that we don't have to prove that the defendant's threats were explicit. The law prohibits even threats that are somewhat ambiguous. Judge Howard will tell you that the defendant, we don't have to prove that the defendant actually intended to carry out her threats. The law prohibits the making of threats alone. Judge Howard will tell you that we don't have to prove that Janet Dlefuoco communicated her threats directly to her victims. Of course, her victims did receive her threats, and you know that the defendant had good cause to believe that they would receive her threats. She knew that her Facebook account was being monitored. Remember this, she posted it once in 2016 and once in 2017. Hello, stalker, I'm doing fine. Thanks for checking up on me. And she knew that judges and Gallant knew that she was posting about them online because her ex-husband and Attorney Gallant both filed motions in Ms. Dlefuoco's court cases for which she would have received copies where they told the judges that she was posting about them online. And Judge Weaver told you that the defendant admitted to him in court that she put up the pornographic post on Facebook. So the defendant's testimony yesterday that she didn't know anyone was watching, that's just false. She knew someone was watching her Facebook page, even if it was only her ex-husband. The ex-husband that she knew liked to take copies of those Facebook posts and run them straight to court. And she knew that what she posted on Facebook would have an impact on those that read the post, an impact on her victims. Remember this post. Has anyone ever wondered that maybe I post stuff and say stuff to screw with your tiny idiotic brain? That is evidence that she intended her words to be understood as threats. She posted this on February 8, 2017, 3 days after she posted her threats. She absolutely intended to screw with her victims' brains. She intended to produce in her victims the state of mind induced by the apprehension of hurt. The First Amendment, freedom of speech, the freedom of religion. Judge Howard will tell you that the First Amendment does not give the defendant the right to threaten to commit a crime or threaten to inflict bodily injury or to terrorize. The defendant can insult, she can swear, she can criticize, but she cannot threaten. The defendant knows what she did was a crime. She told you that yesterday when she said that what she did was wrong, but what she did was very bad. She didn't take those posts down 2 hours after she put them up on Facebook because they were wicked expressions of karma. No, she took them down because she knew they were threatening. She chose the words she knew would make an impact on the victims. She chose words that were violent. She chose words that were threatening. The defendant retaliated against the judges. She threatened the judges and Attorney Gallant. We're here because what the defendant did on February 5th was a crime. And the evidence, including the defendant's own testimony, establishes that beyond a reasonable doubt. We ask that you find the defendant guilty of the crimes as charged. Thank you.
Thank you.
For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced, one way or the other, you must be before you reach a verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions that I'm about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law that you must follow in reaching your verdict. It is up to you to decide the facts in this case. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts, and in this way reach a fair and just verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. There are certain matters that you may not consider as evidence. I will discuss those matters first, and then I will turn to the discussion of what you may consider. The fact that Ms. Dlefuoco has been arrested and charged is not evidence of guilt. The charging documents are simply a way of giving her notice of the charges against her. They are a formal way of accusing her of a crime in order to bring her to trial. You must not consider the charging documents as evidence of guilt of the defendant. The possible punishment of the defendant if you return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. The fact that Ms. Dlefuoco represented herself in this case cannot be used by you in any way in reaching your decision. During the trial, I gave you instructions that certain evidence was stricken from the record, or that certain statements or questions were to be disregarded and not to be considered by you. You are required to follow those instructions and not consider any evidence that has been stricken from the record or consider any matter that you have been instructed to disregard. During the trial, I gave you a limiting instruction which allows you to consider certain evidence only for the purpose for which it was admitted and no other purpose. I'm going to repeat that instruction here. You heard evidence that Ms. Dlefuoco participated in a telephone conversation with Sandra Pease, an employee of the clerk's office of the Rockingham Superior Court. Ms. Pease described that conversation giving her potential concerns, or as giving her potential concerns for the safety of court personnel. As I instructed you during the trial, that telephone conversation is not the subject of any criminal charge in this case, and you cannot convict Ms. Dlefuoco for anything she may have said in that conversation. Rather, you may use that evidence only as it may or may not reflect on her intent or the nature of the Facebook posts that are part of the charges in this case. You've heard the parties discuss the facts and the law in their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence in the law. If the parties have stated the law differently from the law as I explained it to you in these instructions, then you must follow these instructions and ignore the statements of the parties. If the parties have stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. During the trial, the parties made objections. The parties are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you may not guess as to what the answer or evidence would have been. If I overruled an objection, you must not give any special weight to such evidence as a result of my ruling. If you believe that I have expressed or suggested an opinion as to the facts in my rulings or how you should decide the case, I have not done so, and you should ignore any such opinion that you believe I may have suggested. It is up to you alone to decide the facts in this case. Having addressed what you cannot consider in deciding this case, I will now turn to what you should consider. In short, you should consider only the legally admissible evidence, which in this case consists of the testimony under oath of the witnesses during both direct and cross-examination, and the exhibits which have been admitted into evidence. It is your duty to consider all of the evidence in the case, no matter who produced it, and give that evidence what weight you think it deserves. You must not guess or speculate. You must judge the case based on the evidence and the reasonable inferences you draw from the evidence. In reviewing the evidence, the length of the trial, the number of witnesses, or quantity of evidence are not important considerations. Rather, it is the quality of the evidence that is important. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. So let me give you a brief, albeit simple, example to demonstrate the difference between direct and circumstantial evidence. This courtroom has windows to the outside. You look out and you see that it is raining. That would be direct evidence that it is in fact raining. You can see it. Now assume that the courtroom has no windows, but that as you are sitting here, someone walks in wearing a raincoat and carrying an umbrella, and both are dripping wet. Now, since you cannot see outside, you have no direct evidence that it was raining, but on the facts that I've asked you to assume, it would be reasonable and logical for you to conclude that it was raining outside. That is all there is to circumstantial evidence. You infer on the basis of reason and common sense from an established fact the existence or non-existence of some other fact. You should consider both types of evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more of the charged offense elements of the charged offenses, then in order to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence. This circumstantial rule does not apply to direct evidence. If there is a conflict between witnesses who offer direct evidence concerning certain facts, you should decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, should decide which witness to believe, if either of them, and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. You, as jurors, are the sole judges of the credibility of a witness and the weight the witness's testimony deserves. That is, it is up to you to decide who and what to believe. If there is a conflict between what a witness says and other evidence, then you must decide where the facts lie. Simply because a witness has taken an oath to tell you the truth does not mean that you have to accept his or her testimony as true. You should carefully scrutinize all of the testimony given on both direct and cross-examination, the circumstances under which a witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. For example, you may consider the following factors: a witness's motive not to tell the truth, the consistency or inconsistency of the witness's testimony, the accuracy of the witness's memory, the witness's intelligence and state of mind, the witness's appearance, attitude, and behavior on the witness stand, the witness's opportunity and ability to observe the matters as to which he or she has testified, whether the witness impresses you as having an accurate recollection of these matters, any relation a witness may bear to any party or side of the case, the manner in which a witness might be affected by your verdict, the extent to which, if if at all, a witness is either supported or contradicted by other evidence in the case. And any bias, friendship, or animosity a witness may have for or against other people in the case. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted, nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You should consider these factors in evaluating the credibility of any witness, including a judge, attorney, or law enforcement officer. After making your own evaluation of credibility, you should give the testimony of a witness such credibility as you think it deserves. If you may accept all of what a witness has said, you may reject all of what a witness has said, or you can accept some or reject some of what a witness has said. In determining the credibility to be given to the testimony of a witness, you should use your common sense, your good judgment, and your life experience. I have addressed what you should not consider and what you should consider in rendering your verdict. I'm now going to discuss how convinced one way or the other you must be. This is referred to as the burden of proof. Now again, as you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which she's been charged. Under our federal and state constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove her innocence. The defendant enters this courtroom as an innocent person, and you must consider her to be an innocent person unless and until the state convinces you beyond a reasonable doubt that she is guilty of each and every element of the alleged offenses. If, after all of the evidence and arguments, you have a reasonable doubt as to the defendants having committed any one or more of the elements of the offenses charged, then you must find her not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or a fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crimes charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. I will turn next to a discussion of the definition of the crimes with which the defendant is charged. The laws of New Hampshire set forth certain crimes. Each crime has a definition. The definition of each crime requires the state to prove that the defendant committed certain act or acts and that the defendant acted with criminal intent. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts, an intent and an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what her intentions were. The word intent refers to what a person mentally believes her physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, she must have mentally intended to do something that is criminal, and she must have physically acted to do something that is criminal. Unless a person both intended and acted to do something criminal, that person has not committed a crime. In this case, there are 5 charges for you to deliberate. Each of the charges against the defendant allege a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt on each. The fact that you may find the defendant guilty or not guilty on one charge should not influence your verdict with respect to the other charge. In other words, you should evaluate each charge individually. I am about to go over the charges with you and explain the elements of each offense that the state must prove beyond a reasonable doubt. I'm not going to read each charge in full because much of the language is identical. Instead, I have grouped the charges this way. 2 of the charges involving Judge David Anderson and Judge Mark Weaver allege a threat to commit a crime against the judges. The other 2 charges allege a threat to cause bodily injury. I will describe those charges and define the elements for you. The full charge and elements are set forth in my written instructions, which you will have in the deliberation room with you. The charged offense of harm or threat to certain government officials. I'm going to read this first charge in full. The defendant is charged with harm or threat to certain government officials on or about February 5th of 2017 as follows, in that Janet Dlefuoco purposely threatened to commit a crime against a member of the judiciary in retaliation for action taken as part of that official's government duty. In that, in statements Janet Dlefuoco posted on Facebook, she threatened Judge David Anderson of the New Hampshire Superior Court in saying, post number 1, quote, "As my aunt just asked me, are you really going to be able to live with yourself with all the pain you are causing your family? My response was, yep, let them all die and to suffer. Hear that, Diane? Suffer." Post number 2, quote, "The judges and that fucking attorney are so next, so next." End quote. Post number 3, quote, "Donald dead. Mother just lost it all. Diane sick. Husband sick. Next is Weaver, Anderson, and Gallant, and I will give you the shirt off my back and heal your diseases, but I am also just as capable of killing you off. Don't ever cross me with corruption and greed." In retaliation for action Judge David Anderson took as part of his government duties. The next charge is an identical charge involving Judge Mark Weaver. With respect to these 2 charges, the state must prove beyond a reasonable doubt the following material elements or parts of the offense: that the defendant acted purposely, that she threatened to commit a crime against a member of the judiciary, and that the threat was in retaliation for actions the judge took as part of his government duties. To prove that the defendant acted purposely, the state must prove beyond a reasonable doubt that she had the conscious object to do certain acts or to achieve certain results. That is, to threaten to commit a crime against a judge in retaliation for actions taken as part of his government duties. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what she was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do a particular act. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. A threat is a statement of intention to inflict harm, in this case to commit a crime against a judge. In this case, the alleged threat involves statements by Ms. Dlefuoco. You have heard testimony that she believes such speech was protected by the First Amendment right of freedom of speech and freedom of religion. Generally, the First Amendment... Yes. such speech was protected by the First Amendment right of freedom of speech and freedom of religion. Generally, the First Amendment protects the right of persons to speak and to practice their religion free from government intrusion. The First Amendment, whether speech or religion, does not give a person the right to threaten to commit a crime or bodily injury against another. In other words, it is no defense that a person may believe they have a right to make a true threat of harm to another. In order to convict, you must find beyond a reasonable doubt that the statements were a true threat. That is, that Ms. Dlefuoco made the statements with the intent to commit a crime against a judge. Although you may consider the following evidence of whether a threat was made, the state is not required to prove that the defendant intended to carry out the threat, or that it was made directly to the judge, or that the judge was actually placed in fear as a result of the threat. Ambiguous or subtle language does not necessarily mean that the statement cannot be a threat. Whether the state has proved beyond a reasonable doubt that the language constituted a threat is for you to decide, just as you are to decide whether the state has proved all of the elements of the offense charged beyond a reasonable doubt. Now, the next two charges are identical, except that the charge alleges that the defendant purposely threatened bodily injury, as opposed to the first two charges, which were to threaten to commit a crime. Otherwise, the language of the charges are identical, and the two charges apply to both Judge David Anderson and Mark Weaver. With respect to these two charges, which, as I said, are set out fully in the written instructions, the state must prove beyond a reasonable doubt the following material elements or parts of the offense: that the defendant acted purposely, that she threatened bodily injury against a member of the judiciary, and that threat was in retaliation for actions the judge took as part of his government duties. The term purposely is, as I defined it earlier. The term bodily injury means any harm to the body of another. The term threat is, as I defined it earlier, and you'll have that full instruction with you with respect to this charge. It is an identical instruction to the one I just gave you. Now, at this time, and this is an additional instruction, so I'd ask the parties to pay careful attention. It's not in the written instructions, but I'm going to be describing to you at the end of my charge that your verdict in this case must be unanimous on each of the charges. So I want to clarify one thing. The state has characterized these charges as alternative charges. There's the threat to commit bodily injury, and there's the alleged threat to commit a crime. In order to find the defendant guilty of any or each of those offenses, the jury must be unanimous on all of the elements of the offense as alleged in that particular charging document. For example, the jury must be in agreement whether it's guilty or not guilty. In the case involving Judge Anderson, the threat to commit a crime, the jury must be unanimous whether there was or was not a threat to commit a crime, whether the state has proved beyond a reasonable doubt that threat. What you are not allowed to do is, if 6 of you, for example, believe that there was a threat to cause bodily injury, and 6 of you believe there was a threat to commit a crime, but you are not all in agreement on the same element, then you cannot return a verdict of guilty or not guilty because you're not unanimous. You must be unanimous on either the intent to commit a crime or the intent to cause bodily injury, or both. But you cannot split your unanimity on those elements. All right? Ms. Dlefuoco is also charged with criminal threatening on or about February 5th of 2017 as follows. In that, Janet Dlefuoco threatened to commit any crime against a person of another with the purpose to terrorize any person. In that, in statements Janet Dlefuoco posted on Facebook, she threatened Attorney Clifford Gallant and saying, and I will not quote those posts again, they are the same language from the other charges. With respect to this charge, the state must prove beyond a reasonable doubt the following material elements or parts of the offense: that she acted purposely, that she threatened to commit a crime purposely is as I defined it earlier. The term terrorize means to cause alarm, fright, or dread, the state of mind induced by apprehension of hurt from some hostile or threatened event or manifestation. A threat is as I defined it earlier, but I'm going to read this to you again. A threat is a statement of intention to inflict harm, in this case to commit a crime against the person of another. In this case, the alleged threat involves statements made by Ms. Dlefuoco. You have heard testimony that she believes such speech was protected by the First Amendment right of freedom of speech and freedom of religion. Generally, the First Amendment protects the right of persons to speak and to practice their religion free from government intrusion. The First Amendment, whether speech or bodily injury, does not give a person the right to threaten to commit a crime or bodily injury against another. In other words, it is no defense that a person may believe they have a right to make a true threat of harm to another, in order to convict, you must find beyond a reasonable doubt that the statements were a true threat, that is, that Ms. Dlefuoco made the statements with the intent to commit a crime against another. Although you may consider the following as evidence of whether a threat was made, the state is not required to prove that the defendant intended to carry out the threat, or that it was made directly to another, or that another was actually placed in fear as a result of the threat. Ambiguous or subtle language does not necessarily mean that a statement cannot be a threat. Whether the state has proved beyond a reasonable doubt that the language constituted a threat is for you to decide, just as you are to decide whether the state has proved all of the elements of the offense beyond a reasonable doubt. The principles of law given to you in these instructions are intended to guide you in reaching a fair and just verdict in this case, which is important to both the state and to Ms. Dlefuoco. You should decide the facts of this case without passion, without sympathy, and without prejudice, but with honesty and understanding. You should be conscientious of a just result in this case, as that is your highest duty as officers of the court. Now that all the evidence is in and the arguments are completed, you will be free to talk about the case in the jury room. In fact, it is your duty to talk with each other about the evidence and to make every reasonable effort you can to reach a unanimous agreement on all the material elements of the crimes charged. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and your original position was wrong. But do not ever change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. No one will be allowed to hear your discussions in the jury room, and no record will be made of what you say, so you should all feel free to speak your minds. Listen carefully to what the other jurors have to say, and then decide for yourself if the state has proved the defendant guilty beyond a reasonable doubt based upon the law as I've given it to you. Should any member of the jury panel leave the deliberation room for any purpose, you should stop your deliberations. You should only deliberate when all deliberating jurors are present to hear and participate in the discussion. Once you have finished your deliberations, please notify the court officer who will let me know that you have a verdict. You will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court on each of the charged offenses. If you are unable to reach a unanimous verdict, please indicate in writing that you are unable to do so on each of the charges and give the paper to the court officer for delivery to me. I will give you further instructions at that point. I do suggest that the first issue you address when you reach the deliberation room is to select your foreperson, and I will leave it up to you to decide how to do that. The duty of the foreperson of the jury is to act very much like the chairperson of a committee, making certain that each and every member of the jury is given a full and fair opportunity to present his or consider each other's views and opinions, and in the final instance, reach your own decision or conclusion. In the event that you have a question about my instructions or the legal issues presented in this case, please put the question in writing, have the foreperson sign the question, and write down the time that you gave it to the court officer. The court officer will give the question to me, and I will furnish a response to you after I've had an opportunity to discuss the question and my response with the parties. Now, I cannot comment on the evidence, as that is not my role. As I previously said, it's up to you to decide or to evaluate the evidence, and you must use your own recollection of it. It's quite common for jurors to send back a question, whether they can have a transcript or a recording of the witness's testimony. The answer to that question is no. You must rely on your collective and individual recollections about the evidence of the case. Now, I am about to make a random selection to determine who will serve as the alternate in this case. While the alternates will not be participating in the jury deliberations at this time, the alternates perform a very important function. We need to be certain that we have 12 members of the jury to deliberate the case to conclusion. If a member of the jury were unable to complete the case, the alternates ensure that we have 12 members to complete the deliberations. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for an alternate to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, not even amongst the two of you. If you do join the deliberations, I will give you further instructions at that time. And when the jury reaches a verdict, you will be returned to the courtroom to hear that verdict. So before I pick the two alternates, the bailiff will show the two alternates where you'll be sitting. What I do require is that the two alternates remain here at the courthouse today during deliberations. If deliberations, we are not in court session tomorrow. If deliberations go into Friday, the alternates do not have to report back to court. However, you do have to give us your emergency contact information in case we need to press you into service. So if deliberations go into Friday, Friday is not the day to take vacation. Make sure you are available to come in if we call. All right? And the process of selecting the alternates is just a little bit less sophisticated than the way we picked you the first time. This always happens to me at least once. Sometimes we have 15 jurors, and I occasionally pick number 15. There is no number 15, so I've got to pick two. Juror number 5 and juror number 9 are the two alternates. Juror number 5 and juror number 9. As I indicated, the bailiff will show you where to sit. Lunch is probably about to be ready, so that will be provided to you as well. On the issue of lunch, I do not prohibit juries from deliberating during lunch if you choose to. I would caution you, though, only to deliberate if you can do so without undue distraction from your lunch. If you think you can participate in a discussion, go ahead and do so, but if you'd rather just have your lunch and not be distracted, then you are free to choose that. But everybody has to do the same thing. You can't have some jurors eating lunch and not participating. Either you all participate and eat your lunch at the same time, or you just not start yet until you finish your lunch. All right?
Your Honor, may we approach before you?
Yes. Go ahead. So, ladies and gentlemen, I will make sure that you have all of the exhibits in the deliberation room with you and a full set of my instructions. So the bailiff will see the jury to the deliberation room.
All rise.
Great, if the parties could just confirm the monitor that all of the fully admitted exhibits are in, and making sure that no exhibit that remains for ID, making sure it does not. All right. Thank you. Oh, and so if you're, at least for the next hour, I think it's okay for you to leave the courthouse campus if you choose to go get something to eat, what have you. But after 1:30, just make sure you're here and available in case there are questions or where you need to be at the court, in court within just a few minutes if we're told there's a question. All right. All right. Thank you.
Do you want to look at these before they go into the jury? No.
You want to try an interview?
Hi.
Do an interview? Okay.
Hi. I'm hanging on.
Do you want to do an interview online with
No, not right now. We'll do it after.
I can't do it in here. We'd have to just step out the door. Anyways.
I was gonna say, let's just go out for a few minutes. Or are you staying here? What do you want to do?
No, we can stop the broadcast and go out. I have a 50-foot limit on the HDMI.
Yeah, let's just go do something for a few minutes. Let's go grab lunch or something.
All right, sure.
I gotta grab some water. I hope they have bottled water downstairs. I hope, or do I have to go to my
There's
truck?
a water fountain right
No,
now.
I can't have that because of the surgery I just had.
Oh.
Oh, what happened?
I had a tumor on my appendix, so they took out the tumor on my appendix and part of my large intestines.
Oh my God.
Yeah.
That's a big deal.
It's all right.
Are you out of work?
No, I'm back. I'm not, I was supposed to, yeah. I mean, the normal thing for a normal person is 8 weeks to 6 months. I went back 2 weeks later. I just, yeah, it's fine. I'm just, yeah. I'm not one to sit home. I can't. I'd be dead. And I couldn't sit home.
Go ahead.
I'm all right. Let me play back in a minute.
Bye.
Thank you.
that's a lot. You know what I mean? Like, it's a lot to go through, you know, and to be arguing for yourself on
I just don't want you to take off and get more angry or aggressive and calm.
Yeah.
If she had a lawyer, the lawyer would be aggressive and she could be being both at the same time. It's very hard.
Very difficult. I can't imagine.
All right, I guess that's it for now. I'm gonna stop this. Are you coming back after one?
Yeah, I